Welcome. I'm a barrister at 1 Chancery Lane. My name is Sarah Prager. I am the chairman of the Travel and Tourism Association of England and Wales. You will all, I think, be familiar with the fact that although the UK is a member state in itself to the EU at the moment, we have three separate legal systems within the member state. So I'm, as I say, the chairman of the Travel and Tourism Association in England and Wales, but there is also a jurisdiction in Scotland and another jurisdiction in Northern Ireland. So I plan to speak to you today about the impact of the COVID-19 virus in England and Wales, because that is the jurisdiction in which I'm qualified. I'm not qualified in Scotland or in Northern Ireland because those are two completely separate jurisdictions within the UK. So I plan today to speak a little bit about the impact of the virus on court proceedings and how we litigators have dealt with the lockdown measures which were brought into place on the 23rd of March in order to deal with the virus. And then I'm going to speak a little bit about the litigation that's come out of it, what I think is going to happen, and the types of litigation that I think we can see coming within my jurisdiction, and how I think my jurisdiction is likely to deal with the issues that the virus is presenting within the travel industry and within my own field. So the first thing that I want to talk about is how our civil procedure rules have changed in response to the virus. Because of the lockdown measures, we've obviously had to work in a different way. And initially, the Ministry for Justice and the Court Service thought that we would be able to continue with court hearings. So when the lockdown provisions were brought into place within the UK, there was an exception, which meant that although we are not allowed to gather in groups of more than 2 people outside the same household, there's actually an exception to that in relation to court hearings. And it was initially thought that we would even be able to continue with jury trials, because we have jury trials in criminal proceedings and we have jury trials in some civil proceedings, such as actions against the police, defamation, and matters of that sort. So it was thought initially that notwithstanding the lockdown, that we would be able to continue with those trials. Now, in hindsight, that looks like a really foolish idea, and actually it never really came to pass. So the jury trials that were going on at the time of lockdown finished, and no further jury trials were being heard, and no trials will be heard by way of jury until this lockdown has ended. That's the current plan. So jury trials have ended, but the court service did want to continue with other trials. And obviously some trials and some other hearings are really important. Trials have to be dealt with. There are urgent applications involving children, applications involving domestic violence, for example, which is something that we have seen, sadly, a great increase in during the time of the lockdown. So those hearings all had to be dealt with. And so the courts have remained open and judges are hearing cases remotely and by way of using new technology. So the court service has remained open, and there is a need for solicitors and barristers, for people who run the court files and for people who run cases to trial, to continue to work. And we're all working at home now. So almost all solicitors are working at home, working remotely, using remote technology, and barristers always did work quite a bit from home because we're self-employed and because when we're not in court, we're often doing paperwork, so we do it at home rather than in chambers. But there is a need for new rules to deal with the new reality that we are all dealing with at the moment. So the first thing that happened after lockdown was that a voluntary extension to our civil procedure rules was agreed between the Association of British Insurers and a group of solicitors who commonly acted for claimants. And that voluntary extension allowed for limitation dates to be frozen, which meant that claims did not have to be issued by claimant solicitors without the appropriate information, without things like medical reports, because of course no claimants are able to be seen by medical experts because of social distancing. So limitation dates were frozen, and that's made life much easier for claimant solicitors. But the corollary of that, the other side of that coin, was that claimant solicitors agreed that they would respond constructively to requests for extensions of time for service of defences. So there was an agreement entered into between those representing insurers and those representing many, many claimants in this country, that they would respond cooperatively and constructively with each other in relation to granting extensions of time and allowing the other side a longer period within which to consider their position. So claimant solicitors get longer limitation periods, defendant solicitors get longer in which to enter a defence. That's supported by an escalation process, which effectively allows for an email and a telephone helpline where if there is a disagreement between the parties about whether someone's being reasonable about something, for example, where the virus is not the thing that's causing the delay, but there's some other problem causing the delay, which always would have occurred even if the virus wasn't ongoing, then you can ring a helpline or email an arbiter who will take a decision as to whether or not that party is behaving reasonably. So that was a voluntary process, and it was regarded by most people in our industry and in the profession as being a really good sign that actually the parties were going to constructively respond to each other, and that there was going to be a spirit of cooperation throughout this period. And of course, without that spirit of cooperation, conducting litigation during lockdown is almost impossible, because we have really quite short periods of time within which usually directions are given for things like disclosure of documents, exchange of witness statements, and so on and so forth. But with that spirit of cooperation, it has meant that there is a longer period of time to enable people to do that, to organise the technology that's necessary, to organise matters even allowing for social distancing. So, for example, we are starting to see now medical practitioners agreeing to use technology to do remote examinations of potential claimants, and that can't happen in all cases, of course, but it is something that is beginning to happen and something that the parties are acting cooperatively to do. The extension expressly states that it comes to an end on the 20th of April, but this period is going to be extended until probably the end of lockdown, unless the Civil Procedure Rules Committee actually enacts legislation that enacts this voluntary extension as being not voluntary anymore and as being part of our rules. The other helpful amendment to the Civil Procedure Rules is a new practice direction. There have been a number of new practice directions that deal with remote hearings and the like, that deal with recording of hearings and matters such as that. But this particular practice direction came into force on the 2nd of April, and again, it's allowing for cooperation between the parties. So previously, within the UK and England and Wales's Civil Procedure Rules, parties could only agree an extension of time of directions by the court for 28 days. So, for example, if a court said there had to be disclosure by a particular date, the parties could agree amongst themselves that that disclosure could take place anything up to 28 days thereafter. But anything beyond that had to be agreed to by a judge. Now, with this new practice direction, in the spirit of cooperation, which we've seen with the voluntary extension, one can agree an extension of time for up to 56 days. So it doubles the amount of time that the parties can agree extensions for. It gives everyone a little bit of breathing space, which means that we can all get used to using this technology, working remotely, speaking to clients remotely, and so on and so forth. The extension also provides that judges will take the pandemic into account when they're looking at applications for relief from sanctions, so where a party has been late doing something, for extensions of time, so where a party is going to be late doing something, and for adjournments, so where a party feels that a hearing cannot take place as a result of the pandemic. And judges, as I say, will take that into account. Now, very probably, of course, that's what would have happened in any event, and judges would have taken the fact of the pandemic and the measures taken to contain it into account. But here we can see an amendment to the Civil Procedure Rules, which actually provides that they will. So a bit of welcome relief for the parties. Now, priority 1 hearings are hearings that will take place in the county court. So work that has to be done. The courts are going to be considering whether or not hearings should continue to take place, even with the current lockdown provisions, the pandemic going on. And they will be prioritising, because it's absolutely clear that not all hearings that would have taken place but for the pandemic will now be able to take place. Partly we've got fewer courts working, partly we've got fewer judges working. Also, the technology does not exist at the moment, as of mid-April, to allow for judges to hear all hearings in all courtrooms. So not all our courts are working. A lot of judges working from home, of course, as well. So this is the work that has to be done within the courts of England and Wales. it cannot be put off to another day. So these are the priority one hearings. Committals. People who are being sent to prison, that's work that has to be done, and it has to be done immediately because people need to know whether they're going to go to prison or not. Committals are, generally speaking, in the civil procedure, only used for fundamental dishonesty. So people who have already been found by courts to be fundamentally dishonest when they're bringing their claims, and as a result of that, there is a suggestion that those people should go to prison, those committal hearings will be dealt with. That's work that has to be done by the courts. Freezing orders. This is where a party has, for example, a bank account, which another party says contains money that should be frozen, that should not be moved. So, for example, where you have a party domiciled abroad that has a bank account in England, that's a bank account that can be frozen, ought to be frozen, in order to prevent them from moving money out of the jurisdiction so that the courts can then consider that money in any future claim. So freezing orders. Injunctions, another piece of work that has to be done by the courts, is really important. So, for example, preventing a party from doing something, or ensuring that a party does do something. So those, again, are hearings that the courts will be continuing to hear. Any applications in cases listed for trial in the next 3 months, and applications where there's a substantial hearing in the next month. So these are cases that really have to be dealt with because it's important that we deal with any applications for adjourning trials. It's important that trials continue and that the work of justice continues to carry on. Any multi-track hearings, so these are hearings that are worth over £25,000 where the parties agree that the matter is urgent. So if there's an urgent matter, that's work that has to be done and the parties have to agree to that. And of course, any appeals in those instances, because otherwise you could just delay matters and that would be work that didn't really have to be done because an appeal would just delay it and it would come off the priority one hearings list. So those priority one hearings are hearings that are continuing in the courts of England and Wales, even though we are under lockdown and even though it may be difficult for the courts to do that work. There are then priority two hearings. This is work that can be done. So some work will not be either a priority one case or a priority two case, and that's work that will just be left until after the lockdown. These cases, priority two hearings, this is work that can be done by the courts if it has time to do it after having done the priority one work. So priority two hearings, infant and protected party approvals. This is where parties have settled a claim for damages, and that settlement has to be approved by the court because the party seeking the damages is either an infant or a protected party, so most probably a patient, someone who's not capable of conducting litigation themselves. Applications for interim payments, because these are payments that ought to be made in order to prevent hardship to a claimant who we know is going to get some damages at the end of the day. Stage 3 assessment of damages, so where we know that, again, the claimant is going to get some money at the end of the day, there's no reason why they should wait if the court can deal with that work. Applications to set aside judgment in default, so where a party hasn't done something and as a result of that, judgment has been entered against them. Small and fast-track trials, so these are less valuable cases where the parties agree that the matter is urgent, again, so they have to agree that there is an urgency about it. Preliminary assessment of costs, and again, appeals in those instances. So again, a list of court proceedings that can be done, doesn't have to be done, but it can be done. Once you have managed to bring your case within a priority one or priority two list, the court will then assess whether the matter is suitable for a remote hearing. It may be that some work, priority one work, for example, is very urgent, but that it simply cannot be done remotely. In that case, it will either be left until lockdown or, more likely, a court hearing will be convened and social distancing measures put into place to enable that hearing to be conducted in real life, live, but with using social distancing in the way that we have been. So using that exception to the regulations that I told you about at the beginning of the webinar, that there is an exception that parties of more than two people can gather together where there is a court hearing. Where possible, of course, the courts are trying not to do that. So we're trying to have virtual hearings most of the time by using the new technology that we're all getting used to at the moment because we're all in lockdown. So the factors the court will take into account as to whether or not a matter is suitable for remote hearing, the nature of the hearing. So is it a priority one or priority two case? If it isn't, then it's probably going to be left until lockdown, until after lockdown rather. The urgency of the matter. If it's an urgent matter, it really ought to be dealt with, and it's going to be dealt with in court if need be. Number of parties participating, because the more the number of parties, the less likely it is that it's suitable for a remote hearing. I had a case a couple of weeks ago which involved 24 claimants, and there were 6 expert witnesses. That had to be adjourned until after lockdown because the court determined that it would not be possible to deal with the case because there would be so many people involved and the technology would just be completely unwieldy. So in that case, the cases had to be left for probably 6, maybe 9 months. And it will take its place in the queue for cases to be relisted after lockdown. Again, of course, whether some or all the parties have access to the necessary technology. There will be a large number of people who simply do not have access to the necessary technology to undertake a hearing involving them. And parties within England and Wales have a right to attend their own hearing. So if you are a party to a hearing and you don't have, for example, Wi-Fi, or you don't have a laptop, you don't have access to a computer, then the case will be left until after lockdown because you have a right to know what is going on at your own hearing. So that is an important factor as to whether or not these cases can be heard. And lastly, whether expert evidence is necessary. In my own practice, I see a lot of gastric cases involving food poisoning and matters of that nature. When people go on holiday, they then claim against the tour operator, or they claim against the hotel for giving them food poisoning. And expert evidence is often necessary in that case, and we are often seeing expert evidence from microbiologists. Again, I had another trial that had to be adjourned a couple of weeks ago because we had 4 microbiologists giving evidence, and none of them were available because they're all dealing with the pandemic. So a lot of microbiologists unavailable, and a lot of medical doctors unavailable too, because they're all dealing with the pandemic. And the court service rightly recognises that that is more important than dealing with litigation, which can be left until after lockdown. So these are all factors as to whether or not your case will be able to be heard within the courts at any appropriate way. We are conducting remote hearings at the moment by way of a number of new technologies. So the ones that I've been using are Skype, with a variable degree of success because quite often one or more parties just drops out of Skype. Zoom meetings, which there were very significant concerns about the data protection in relation to those and as regards to security, but those concerns seem to have been allayed. Telephone hearings have always been conducted within the courts of England and Wales. We've been doing that for 20 years. They're getting more prevalent now. And if none of those are appropriate, the court can always deal with the hearing on the papers by way of email. So those are all options that the court has in enabling us to deal with matters remotely. Now, that's all I would plan to say at the webinar as regards to how the courts are dealing with the pandemic and how they're dealing with continuing to conduct litigation within the court service, because there is a real will within the court service of England and Wales to keep those hearings going, to keep the remote hearings appropriate, and keep the technology going to enable those hearings to take place. So just a few words now about the litigation that we can see coming in our jurisdiction. I'm actually not aware of any claims having been issued as against the travel industry in relation to the pandemic. So we in England and Wales have actually been quite slow starters in relation to litigating in relation to the pandemic and in relation to the travel industry. But what we can do is learn our lessons from litigation which is ongoing in other jurisdictions. So quite an interesting one here, the Canadian Airlines claims, where a class action is being brought against 4 Canadian airlines in relation to cancelled flights. So as you see here, in mid-March, the Canadian government advised against non-essential travel. The claimants' flights were cancelled, they were offered rebooking but not a refund, and they're seeking a full refund, which is what they say they're entitled to under the terms and conditions of their contract. Now, the airlines in Canada defend the claim. They say that they're not entitled to a full refund on the basis of force majeure. So they are saying that the pandemic constitutes something which was unforeseeable, unforeseen, and is effectively an act of God. That's a defence which would not be open to airlines within Europe because, as you know, of the denied boarding regulations. And under those regulations, passengers are entitled to a full refund, and there can be no argument about that unless, of course, it's unusual, unforeseen circumstances which could not have been forestalled with reasonable care. So that litigation, quite interesting, giving us an idea as to what may happen within the courts of England and Wales. Of course, at the moment, our airlines are actually refunding without any question. So they're providing refunds. And that's being done across the board in England and Wales. So there's no need for any litigation at the moment because refunds are being given. How long that will continue for is impossible to say. But we have had a number of airlines collapse. So we had Monarch collapsed in 2017 and Flybe collapsed in early 2020. And that was very shortly after the pandemic was announced by the World Health Organization as being a global emergency and not actually related to that. So we can see in England and Wales that there is likely to be litigation arising out of the collapse of airlines, but it's less likely that there will be litigation arising out of refusal to refund. So that's just a little snapshot of what I think is likely to happen in relation to airlines. This quite an interesting claim, the Tyrolean resort claims, and this, as you'll know, is the group action being brought against the Tyrolean ski resorts, and is really quite a big class action. A lot of German claimants in that one against the Austrian resorts. And as you see there, the claimants assert that the local authorities failed to close the resort, even though they knew that a bar employee, which was someone who was working in a bar, which was very popular amongst travellers, amongst skiers, had tested positive for COVID-19. And he's now been known as a super spreader. So he has, we know, infected unknowingly a number of skiers from all over Europe, and some of them are from England. Is there going to be litigation within the courts of England and Wales in relation to that particular infection? My feeling on that is probably not, and the reason being that the courts of England and Wales are not going to have jurisdiction over any such claim because, of course, the ski resort will have to be sued in the courts of its domicile, which effectively is Austria, and I can't see a way of bringing a foreign resort within the jurisdiction of England and Wales. So very probably no litigation in that particular case within England and Wales, although we may see some English claimants within the wider litigation which is being brought in Austria. However, the courts of England and Wales do have jurisdiction in some worldwide cases. So in cases in which European legislation is applicable, we will not see resort claims being brought within England and Wales because those claims would have to be brought within the domicile of the resort, so Austria or Spain or wherever the case may be. However, in the wider world, we could see litigation being brought as against, for example, Indian resorts or African resorts, South American resorts or North American resorts possibly. We have had claims brought in this country against an Indian hotel. And the English courts accepted jurisdiction over those claims in relation to a terrorist attack, actually, some years ago. And the English courts accepted jurisdiction in relation to those claims because they considered that it was a convenient jurisdiction within to bring them. So it was convenient for the claimants because the claimants were domiciled here. And it was convenient too for the defendant, so the court found, because the courts of India would take such a long time to consider the litigation and for the litigation to come to an end. So the English courts accepted jurisdiction over that particular claim against an Indian hotel domiciled in India. And that suggests to me that there is a possibility of English courts accepting jurisdiction against, for example, a Chinese resort or something of that nature, where there might be a doubt as to whether the litigation could conveniently be brought within the courts of the domicile of that particular resort, and therefore the English courts would take jurisdiction over it. So it is a possibility that claims could be brought within England and Wales as regards the spread of the coronavirus in a foreign resort. That's a theoretical possibility. It may happen. It hasn't happened yet. Another interesting claim being brought, and again, this is a wider world claim, as it were, not a European claim, and this is actually a resort suing tourists. So, a very popular island resort just off South Korea, very popular with South Korean tourists, is suing two tourists for travelling to the island when one of them had been advised to observe quarantine. This was someone who had come back from a university course in Boston and who had come back to visit her South Korean family. And she and her mother decided to go off to this tourist resort in South Korea. And the daughter began to exhibit symptoms a day after arrival, and they remained on the island for a further 4 days, came into contact with at least 47 individuals. We know because South Korea is very good at tracing contact, and that's something that they've been doing to try and contain the spread of the virus. And they went to 20 different locations, as a result of which those individuals, when traced, then had to quarantine themselves for 14 days, and those 20 locations, some of them had to close down, these businesses. So the proceedings are brought by the province itself, so by the resort itself, and by some of the individuals who had to quarantine as a result of being traced when the mother and daughter then subsequently tested positive for coronavirus when they returned to the mainland. And some of the businesses are also suing for loss of business because they had to close down because they were advised that they had been contaminated by these individuals. So really interesting example of litigation here of rather than consumers litigating against suppliers, an example of resorts and businesses and indeed individuals suing the consumer. Can I see this being rolled out across the wider world? No, I can't. There's no theoretical reason as to why that should not take place within the courts of England and Wales. So there's no reason why, for example, an English resort or an Austrian resort or a Spanish resort should not sue someone who is patient zero, who brings the coronavirus into that resort. I find it quite difficult to conceptualize how an English court would deal with that, but there is no reason why they should not. So, for example, the H10 hotel in Tenerife, which we know had to be locked down and tourists quarantined there because an Italian doctor unknowingly took the coronavirus into the hotel and then it spread around the hotel. In that circumstance, it is theoretically possible for the hotel to sue the Italian doctor for having brought the virus into the hotel and contaminated the hotel, causing it to lose business. Is an unattractive claim, and I think it would be very difficult to bring such a claim, and I think an English judge would be very reticent about allowing such a claim to succeed. But it is a theoretical possibility. It is something that could happen within the courts of England and Wales if an English domiciled person were to be identified as being patient zero in such a circumstance. So an interesting piece of litigation, one that I really can't see being rolled out to any great extent. A number of cruise claims are being brought, and these are largely being brought in America against American cruise operators. There's a number of them. So there's a class action being brought against Costa Cruises in Miami, where the claimants alleged negligence against the cruise operator because they allowed a cruise to take place, even though some passengers were showing symptoms of COVID-19. This happened quite early on in the outbreak, so it may well be open for the cruise operator to say that they should not be liable because they were not aware of quite how severe this outbreak was going to be. And there are also some really interesting American maritime legislative provisions to do with death on the high seas and to do with how cruise operators owe duties to passengers. And this means that such a claim would be really quite tricky to bring, certainly in America. But nevertheless, a class action is being brought in Miami against Costa Cruises. There's another one going on in California. And this is an American couple suing Princess Cruises in California for damages of over $1 million. Because they say the cruise operator allowed a cruise aboard a vessel to take place when it knew or ought to have known there had been an outbreak of illness on a previous cruise on board that vessel. And they say that the vessel was still contaminated at the time of their cruise. So they allege gross negligence in relation to failing to provide them with information in relation to the previous cruise, in failing to tell them there was a danger that the vessel was still contaminated, and in failing to screen passengers before they came aboard the second cruise that they were on. There's another claim afoot in Australia against Princess Cruises again, and this is in relation to the Ruby Princess, which suffered an outbreak on one cruise, and indeed there are another 700 passengers involved in a further cruise aboard the Diamond Princess. So Princess Cruises is really having a difficult time of it at the moment. And they are being sued in America, and a class action is afoot in Australia as well. So there's allegations being made not only in relation to the cruise operator in those cases, but also in the Australian case, in relation to the Ruby Princess, there are allegations being made against the port authorities that they didn't handle the disembarkation of those passengers and the dissemination of the passengers when they left the cruise in an appropriate way. So that litigation being brought against cruise operators. And I can see that would give rise to some issues that the English courts would find attractive, and that the English courts might well be prepared to say, well, look, cruise operators who know that the vessel is contaminated really ought to deep clean it before they turn it around and send it back out again. If they haven't deep cleaned it, there's going to be an issue, and there is going to be an allegation of negligence and fault under the Athens Convention, which of course applies to English cruises, of fault in failing to deep clean the vessel, in failing to screen passengers before they get on board the vessel, and in failing to quarantine passengers if need be, if an outbreak does occur on a cruise. So I think these cruise claims are quite interesting, and I think there is a likelihood of cruise claims being brought within this jurisdiction. The only issue that I can foresee arising in relation to those claims, which would give difficulty, is in relation to the cruise operators and where they are domiciled, where the cruises have been offered for sale, and so on and so forth. But as long as there is a connection with England, as long as the claims are being brought by English people, for example, as long as the passengers are English, or as long as the cruise operator is English or is directing its operations towards England, there ought to be no difficulty in relation to that. So where do I see claims arising in the future? Well, really quite a large number of categories of claim are possible. In relation to airlines and tour operators, there ought to be refunds given in relation to flights that can't take place and package holidays that are not taking place. The airlines are providing refunds. The tour operators are not providing refunds. So in relation to the package travel and linked travel arrangements regulations that we have, which give rise to liability in accordance with the underlying directive, those refunds are not being given. And passengers and travellers are entitled to refunds under that legislation, and they're not being provided with them. So that's a really serious issue that I can foresee any number of class actions arising as a result of that, and tour operators being sued for refunds, which they are supposed to be giving. The difficulty for tour operators, of course, at the moment is that so few holidays are being booked and so many holidays are being cancelled that they actually cannot afford to give refunds. And one of the problems that they are seeing is that the accommodation and other suppliers abroad are not providing them with refunds. So they've booked hotels, for example, for the whole summer. They're not being given refunds for the bookings that they had made in relation to those hotels, and therefore the tour operators say, well, we can't afford to refund consumers because we're not getting refunds ourselves. So there's a knock-on effect there. It seems to me that it's quite likely that people who have booked package holidays and who've not been provided with refunds are likely to sue the tour operators, but the tour operators are then themselves likely to sue their suppliers for failing to provide refunds. And depending on the terms and conditions of their contractual arrangements, it may well be that both of those claims will succeed, but actually more likely, it seems to me, that the tour operators will have to provide refunds to the consumers, but will then not be able to claim against the suppliers because there will be a force majeure argument made by the supplier. So those claims are really quite difficult for tour operators, and where I think the danger is for them. There will be personal injury claims, of course, because if people go on holiday to an accommodation supplier, so if they go on holiday to a hotel, for example, the H10 hotel in Tenerife that we were talking about before, if they go to the H10 hotel and it did not produce good lockdown measures, so it didn't quarantine tourists coming in, even though it knew that there was someone there spreading the virus, then a personal injury claim would arise, and the traveller would be able to claim against the package holiday supplier, who would then claim against the accommodation supplier. So personal injury claims, it seems to me, quite likely to be made where people have gone abroad and they've contracted the virus within the hotel. Again, it will be possible for consumers to sue British resorts and hotels for failing to contain the virus, and it will be possible for them to sue foreign resorts and hotels where they can establish jurisdiction in the way that I was speaking about just a little bit earlier. Seems to me there's also likely to be clinical negligence claims against the NHS for failing to contain the virus. A lot of people are going to hospital at the moment for unrelated reasons. For example, we had a 99-year-old veteran who went to hospital the other day with a fall. He survived the fall, but he caught coronavirus whilst he was in hospital. Now, thankfully, he survived that as well. So a success story there, but really failures on the part of the hospital to contain the spread within the hospital. There'll also be likely to be clinical negligence claims against foreign hospitals for similar reasons. So where similar things happen in foreign hospitals, that's a claim that could be made by the English consumer against the foreign hospital in relation to clinical negligence there. And again, employers' liability against British and foreign employers. So where, for example, you have air stewardesses working on airlines and they're contracting coronavirus from air passengers, there will be a potential claim in relation to those claims. So quite a lot of options for future claims arising out of this pandemic, and we can already see that there is likely to be claims brought because claims are being brought in foreign jurisdictions. But however, as I have said, no claims yet brought within the jurisdiction of England and Wales. So it's very early days and it's very difficult to predict quite how the courts are likely to deal with those claims. So just to return to the key issues of this webinar, it seems to me that the courts are staying open at the moment in England and Wales. We are trying our best to do business as usual, but difficulties are arising in relation to the use of technology, in relation to people's access to technology, and that's always going to be something that's an issue, it seems to me. In relation to the litigation that I foresee happening, I can foresee claims being made against airlines, although they, it seems to me, are largely complying with their legal obligations in relation to this pandemic, but much more likely claims made against tour operators for failure to refund the cost of package holidays, because a lot of tour operators are not doing that, and they are not entitled to do that as the law as it now stands, as at mid-April. And it seems to me, lastly, it's quite likely that quite a lot of claims are going to be made in relation to cruises, because not only are cruises being cancelled, although the cruise operators are providing refunds for those, but a lot of people have caught coronavirus whilst being on cruises, and that it seems to me is really the likely to be the hotspot in relation to litigation, certainly in my experience in England and Wales, because we do, of course, have experience of another coronavirus, which is to say norovirus. And a lot of claims have been brought historically against cruise operators in relation to norovirus, and that is something which has given rise to a lot of litigation in the past, and I think we can learn from that litigation when we think about what is likely to happen in the future in England and Wales. In the meantime, I wish you all very good health. Thank you for bearing with me as I just give you a very brief canter through what's happening in England at the moment. Absolutely lovely to see you, and I hope that you're all social distancing, staying safe, and hopefully sometime soon we will all be able to go on holiday again. Thanks very much for being